Number 5 of the House Commons Standing Committee on Finance, and we're welcoming a couple of new recruits here to the Finance Committee this evening. Thank you for coming. The committee is meeting today to conduct committee business, as we've been doing for a little while. Pursuant to the motion adopted by the House on Wednesday, September 23rd, 2020, the committee is meeting virtually. Today's meeting is taking place by video conferences, and proceedings will be televised and made available on the House of Commons website. I don't believe it's necessary for me to repeat all the rules, as we don't have any witnesses before us. I think committee members are well aware of the rules. When we adjourned last, it was reported that discussions would be ongoing to achieve, hopefully, an agreeable settlement on the motion in the name of Mr. Poilievre. I take it there's no agreement has been reached as yet, although I understand considerable progress is being made. Therefore, we'll start where we left off on the sub-amendment to the original motion by Mr. Poilievre. And I have on my list to start off the engagement tonight with Mr. Fragaskatis, followed by Ms. Zerowitz, followed by Mr. Julian. Mr. Fragaskatis.
Thank you, Mr. Chair, and it's good to see colleagues. I won't take too much of the committee's time, Mr. Chair, but I just wanted to take a few moments, if I could, and kind of recap where we are here. Because I know for those back at home, after weeks of watching, it could be easy to confuse why we are here. We have our initial motion, which pertains to Mr. Poilievre's matter of privilege in relation to redacted documents. Now, these documents were received by this committee in accordance with the motion that was passed by committee members. The documents were in the format as requested in the motion and were provided on time. The redactions that Mr. Poilievre seems to be taking issue with, it would appear, are directly related to the work done by the parliamentary law clerk. Now, I can appreciate that Mr. Poilievre is not happy with the results of a motion that he requested. However, it was his party that drafted the original motion. Subsequently, we have an amendment and sub-amendment on the table, all related to the production of documents and which version of documents should be disclosed and how they are compared and whatnot. I won't waste time going into details on that. Yet what is key to the sub-amendment, Mr. Chair, is the appearance of the Clerk of the Privy Council. As my colleagues have noted previously, and as my opposition colleagues are fully aware, we are in possession of a letter from the most senior civil servant in the country. The Clerk of the Privy Council and Secretary to Cabinet is the head of our civil service, is the head of the Privy Council office, which coordinates the functioning of government in Canada, and as Secretary to Cabinet is the Chief Advisor to Cabinet and responsible for the accurate recording of meetings and decisions. Clearly, the Clerk is in a position to be an expert witness on any number of matters, particularly because it was the Clerk that preemptively ordered the release of documents, including cabinet confidences, and the names of relevant public servants prior to this committee making its motion. Now, I think it's important we focus, Mr. Chair, for a moment here on the matters at hand. As I noted, the Clerk is the Secretary to Cabinet and responsible for keeping information related to Cabinet. As a result, he is the keeper of Cabinet confidences. He can choose whether or not they are waived in a particular circumstance. And as he did in the matter of the Canada Student Service Grant, he did choose to waive confidence and provide all documentation that flowed through the Cabinet Papers system. The Clerk committed to doing this before we even voted on requests for these documents. Now, further to his responsibility to keep Cabinet confidences, the Clerk did take the position that matters that were unrelated to the student service grant should not be disclosed. Is this an unreasonable position? I think not. Is this position by the Clerk to redact unrelated Cabinet confidences outside the normal scope of practice? No, it is not. It is outside the normal scope of practice for department officials? Is it outside the normal scope of practice for department officials, nonpartisan public servants to redact said documentation at point of source? No. Is it outside the normal scope of practice for the public service to provide completely unredacted cabinet documents to the parliamentary law clerk, and for him and him alone to choose what should be redacted as a cabinet confidence? 100%, absolutely. And this is exactly what Mr. Poilievre and my opposition colleagues are calling for here, Mr. Chair. The opposition majority is calling on this committee to take a position regarding document requests that is very far outside the normal practice. And it's not just happening here, Chair. We see this happening at other committees as well. And we also see it with the structure of the motion the Conservatives made in regards to their opposition motion the other week. Again, requesting documents unredacted and calling on the law clerk to make those redactions for cabinet confidences. The parliamentary law clerk has never had powers to review cabinet confidences, and there are legal precedents and reasons for this, very good reasons, Mr. Chair. And just for colleagues' information here, I am on point in relation to our sub-amendment. I just believe that setting proper context is important. You will fully understand my point momentarily. So as I have explained, the way in which the majority opposition is requested documents is rather unorthodox and out of the ordinary. To make it even more interesting, the original motion drafted and passed by the opposition recognized that unrelated cabinet confidences would be redacted at source and then forwarded to the law clerk for a personal privacy check. The motion was structured and passed in that way, and no one from the opposition said otherwise. So imagine our surprise when Mr. Poilievre appeared post-document release, dramatically throwing blacked out papers around a press briefing, papers he received from the law clerk and conforming to the exact specifications of a motion that he proposed. Now, this brings me to the clerk of the Privy Council. In mid-August, the government House Leader released documents, the exact documents that the clerk had promised and that the clerk had requested in its motion, minus the redactions by the law clerk. This was an extraordinary release of Crown secrets. As has been said in this committee in the past, this release of documents was unlike any that had occurred in the past. Included in the information was reference to specific public servants, which the clerk took the extreme step of leaving unredacted. This required the clerk to file a notice with the Privacy Commissioner advising him of his move. I think colleagues need to let the gravity of that decision sink in. So we now have two sets of documents: the lightly redacted information from the government House Leader, which saw the complete release of information as it relates to the CSSG, or the Canada Student Service Grant, minus unrelated cabinet confidences, which included the names of public servants. And we also have the documents from the law clerk, which are a bit more heavily redacted, removing the names of public servants, phone numbers, and emails, among some other items. Now, the opposition has taken issue with the pre-redactions made by the public servants in relation to unrelated cabinet confidences, which again, I find strange considering that this was in the motion from the committee, is the regular practice when documents are sent to the committee as well, though clearly this doesn't fit the partisan narrative of the majority opposition. So Mr. Poilievre, Mr. Julian, and others have concerns about these pre-redactions. We can debate all day about how this was to be expected because of the motion that was passed. However, let's set that argument aside for a moment. As I've said, the clerk of the Privy Council is the keeper of cabinet confidences and is an expert witness when it comes to their release. He has offered to come before this committee, Mr. Chair. That letter sent by him states clearly that he and his relevant deputy ministers would gladly come before the committee and explain how they went about reviewing the motion from the committee, compiling documents, and complying the best they could with our request. And I know this has been reported in the press as well, and so Canadians across the country will be aware of this fact too. Personally, I'm not sure why the opposition has questions about why there were redactions for unrelated cabinet confidences. But Chair, I get that they have their political game to play. So I'm willing to play ball on some level. That is why I think it's completely reasonable to have the clerk and his fellow deputies here to explain themselves. What I do think is important for us to remember is that, like us, the amazing public servants that work for the Government of Canada swear an oath to uphold the secrecy of all matters that come before them in their duties, and to uphold the statutes that govern privacy laws in Canada. So as we push these public servants for the release of information, they are conducting a delicate balancing act, Mr. Chair, between our rights as parliamentarians to reasonably access government documents and their sworn reasonability to uphold the confidence of the cabinet process and protect the functioning of responsible government. I think that up front, the clerk should be commended. He recognized that this program, while on its merits was a good concept, as far as a program is concerned, clearly had issues on the implementation front. He recognized the need to be 100% upfront and transparent in regards to how the CSSG came into being, and he ensured that the cabinet documents relating to its creation and approval were made available for parliamentarians. However, as committee members, we have to recognize that this unprecedented move to make the information available had to be balanced with the need to protect cabinet confidences on matters that were unrelated. If we accepted the request from the clerk to appear, I think that is what he would tell this committee. I think he has a measured and reasonable explanation for why some information was released and other information was not. I think the testimony he will give will side with the fact that it is not the responsibility as clerk of the Privy Council to assist the official opposition with their politically motivated fishing expedition. That it wouldn't be appropriate for him, Mr. Chair, that it wouldn't be appropriate for him to unredact information for purely political reasons to help the opposition, that it would taint the cabinet process. And all of these explanations would be better heard coming from the lips of the clerk himself. So, Chair, I think we know what colleagues on the other side are afraid of. I think they are rather annoyed that we will not allow the tyranny of the opposition majority to rule supreme here in this place. I think they are annoyed that a nonpartisan professional public servant is willing to come forward and testify, and that the testimony would be given is likely to counter their narrow partisan strategy. I encourage all my colleagues to vote in favor of the sub-amendment, to allow the clerk to come forward and explain the position of the government in regards to redaction. It's the right thing to do. So I ask colleagues to do the right thing. Allow the clerk to come before us. Let's move past this matter after he testifies and get to the work that Canadians expect of us. In particular, I'm very much looking forward to discussing the motion from Ms. Derowitz regarding pre-budget consultations. It's the whole reason this committee exists. Let's hear from the clerk, and then let's get to the work on the pre-budget planning, Mr. Chair. And I think that's a critical point, and one that is quite relevant, Mr. Chair, because if we think back, this debate around Mr. Kelly's amendment and the sub-amendment that has been proposed by the Liberal side, really, as we continue with it, and I think we should because the sub-amendment is tremendously important, does stand in the way of us looking at Ms. Derowitz's motion, which is completely on par with what this committee, as I just said, needs to do. Commence pre-budget consultations so we can begin to hear from Canadians but what their priorities are. As we face a second wave, COVID-19 continues to impact almost every part of this country in some shape or form. I know in my own province in Ontario, we are seeing real challenges here, not only in the GTA in Ottawa, but also in other parts too. And so I think as we start to grapple with it, we need to hear from experts, particularly on the economy, and to consider how COVID-19 is impacting the land. And I can't emphasize enough to my colleagues how imperative it is that we move in this direction, because if we think back to when we were elected, what was it that we were sent here to do? The committee process for all MPs is central to the job of being a parliamentarian. As far as the And we all know that this job is many things. It's really two jobs at the end of the day. You have the constituency work that is vital, but you also have the work on Parliament Hill that takes place. And on that latter point, the work on Parliament Hill, our committee work is so crucial, so imperative. I've had the honor of serving on the Committee for Foreign Affairs, on the Committee for Public Safety and National Security, and now for the previous 2 years, Mr. Chair, under your learned leadership, and I say that very sincerely. I know you're a modest man and you're shaking your head there. You should not. You've led the committee in a very able way, Mr. Chair. It is a tremendously important thing to sit on the Finance Committee, and the work that we do, I mean, it is varied. We have had a role in the planning of, or at least the gathering of ideas that relate to COVID-19 and the economic response, the gathering of ideas that finds its way in the form of recommendations for the finance minister to consider, for the prime minister also, of course, to consider. That is not a small thing. That is something that I know I obviously and colleagues around the table will take pride in, but our constituents feel a great amount of pride when they know that they have MPs who represent them who sit on this committee, arguably the most important committee on Parliament Hill. And so as we've engaged in these debates, I've thought back to what it is preventing from happening. But until, and it is obviously preventing us from dealing with Ms. Darowitz's motion, which is calling on us to begin immediately pre-budget consultations. But that doesn't mean that this debate is one that I'm willing to simply surrender to the opposition, because there are a number of things at stake here, Mr. Chair. We have the clerk of the Privy Council who has made the very important point that he wishes to come before committee and to be asked questions, not only by members of Parliament on the Liberal side, but by opposition members of Parliament as well. It is an extraordinary move on his part, and we see the opposition standing in the way of that happening. And this is where I have real concerns, Mr. Chair. We have not dealt with this point that I'm about to make at this committee in previous meetings, but it has been suggested, especially by Mr. Poilievre, and I'm disappointed to hear, or not to hear rather, opposition colleagues challenge him on this point. But I will tell you, and I think I speak for the entire Liberal side, that when Mr. Poilievre has suggested that it would not be something that he would be open to, he would not be in favor of having the clerk appear before this committee, because in his view, the clerk operates at the whim of the prime minister, as Mr. Poilievre, I think, put it, somehow under the thumb of the prime minister, is reliant, is dependent. That's the word he continues to use. Mr. Poilievre has said that the clerk of the Privy Council is dependent on the prime minister. It's just not true. The most senior civil servant in the land is, by definition, neutral and objective. They must be in order to carry out their role, which is what? The clerk has the most important role in the public service. And we need to make sure that while there will be naturally quarrels between members of Parliament on opposite party sides, that we do not attack the public service, which as we have seen, Mr. Chair, the issue of the day is COVID-19. Were it not for the federal public service, not to say, I mean, we could also talk about public services operating at the provincial and municipal levels, but I won't do that. I'll focus on the federal public service. What a tremendous and extraordinary job they have done through COVID-19 by suggesting that the head of Canada's public service is somehow under the rule, entirely dependent, as Mr. Poilievre put it, of the Prime Minister of Canada, is not only something that besmirches the reputation of this particular clerk, it besmirches the reputation of clerks previous and those that were come after Mr. Shugart. It also attacks the reputation and honor of existing public servants at all levels, whether they are public servants who just recently joined Canada's civil service or experienced ones as well. I wonder why it is that my conservative colleagues continue to do this almost at every opportunity. And it surprised me as well that Mr. Polyev made the point, because he speaks very highly, at least he has in previous sessions and meetings of this committee. In the previous parliament, for example, I remember him putting on record that he held Mr. Shugart in high esteem. That was an interesting point, but one that he completely contradicts when he says that Mr. Shugart is under the thumb of the current prime minister. It's just not the case. Mr. Shugart, in fact, if I'm not mistaken, Mr. Chair, when Mr. Polyev served in cabinet, Mr. Shugart was the deputy minister to Mr. Polyev. So, has served under a number of different governments. All of which is to say, Mr. Chair, that the moment we begin to attack public servants is the moment that we see a tide or a shift in our democracy that we should absolutely avoid. All of us are in this position as members of parliament, a position that will not be forever. You know, we are here for sometimes a few years, sometimes a good number of years, Mr. Chair. The reality is that partisanship plays a role in that process. We've decided to approach our public service in that way. But public servants who decide to work in the civil service, making a contribution along those lines, want nothing to do with politics. And so once we begin attacking them, we violate a cardinal rule in a democracy, and that is that the public service must never be politicized. Public servants are not politicizing this process, but by making the accusations that Mr. Polyev has put forward, and which again I emphasize to my amazement that the opposition has not intervened to correct him or to voice their view on the matter, we take away, we do away with the need to ensure that our democracy, in terms of the public service, is free of politics. There's another thing too here, and this point was, I remember Mr. Gerritsen suggesting this, although he didn't complete the thought, if I remember, when he sat at this committee a few weeks back, and that is, we have to be very careful about how we decide to engage discussions around the public service, because they're not here to defend themselves. Public servants, you know, when Mr. Polyev makes these accusations, he does so without a public servant present, without Mr. Shugart and other public servants present. That, to me, is an offensive thing, Mr. Chair, because public servants are not to be attacked for all the reasons that I've laid out, but also because it's not their position to engage in these debates. I think Mr. Shugart realizes that, but in a very honorable way, has put forward a letter to this committee so that he can be heard. And if members of the opposition at that point wish to engage combatively even with him, I suppose that can happen. But to launch these accusations without the clerk of the Privy Council present, I think is really quite extraordinary, and something that I don't think I've seen at any committee level. And I wonder, Mr. Chair, if it's happened before in previous committees during times past within parliamentary history. Perhaps it has. I mean, that parliamentary history is long, but I'm going to assume, because of the strength of our democracy, that the times it has transpired, they're few and far between. So, Mr. Chair, this point about not attacking the public servants who serve this country, and especially—
Point of order, Mr. Chair. Mr. Chair, I can't hear you. I had mentioned I have a point of order. I don't know if you've given me the floor now. I can't hear you.
You hear me there now? Hello?
Yes, I can hear you. Thank you.
Okay.
And I hate to interrupt, but Mr. Fredriskanis has repeatedly asserted falsely, incorrectly, that that there were these wild accusations or even criticisms made of the clerk of the Privy Council, which is not correct.
I review the record if I was you, Mr. Kelly.
Mr. Polyev did not attack Mr. Shugart in any way. He pointed out that he is an employee of the Prime Minister, and
he said he was dependent called him on the Prime Minister.
That's not an attack. That's not an attack. And he in fact went on to assert that he was, I believe, if I can quote him from the record, I think he referred to him as a heck of a guy repeatedly. I don't think that he at any point attacked either the integrity or the
I think, Mr. Kelly, we're into debate more so than a point of order. But if you want to come in later and make that point, you're welcome to it.
One of the points, the point of order was on the correction of the record. The other point of order I have would be relevance. You strayed far beyond the sub amendment.
All right, on relevance, I can take, and I'll go to Mr. Fragaskatis on relevance. I do think, in part, he was refuting an argument that was made in a discussion by a member previously. But before I give you the floor again, Mr. Fragaskatis, Madam Clerk, you will have to give me a signal if Mr. St. Marie wants in. I usually can see him on my screen even when he's in the room, but I can't see him tonight. So you can just give me a shout or wave your hand if he happens to want in. Mr. Fragaskatis, you get the floor.
Well, thank you, Mr. Chair. It was an interesting point of order, and I think you ruled it a point of debate. And in that vein, I'd like to thank Mr. Kelly for his intervention, because when he says that, well, I see he's now put his thumbs up. What he doesn't realize, he just gave me a new track to follow, one that is actually entirely relevant to the discussion at hand, Mr. Chair. And that is when Mr. Kelly says that the attack didn't happen because Mr. Polyev was actually honoring in some way Mr. Shugart. He did have some good things to say. He's also put that on the record in previous meetings. But when Mr. Polyev uses the word dependent, it implies that the clerk is not independent. And to make that kind of an accusation against the clerk of the Privy Council of Canada is probably the ultimate insult that can be launched towards the highest ranking public servant at the federal level that this country has to offer. So I won't belabor that point. But it's an interesting intervention on the part of Mr. Kelly, who, he knows I have respect for. I've been open about the way that I've worked well with Mr. Kelly in the past. In fact, I first met him when we carried out pre-budget consultations a few years ago. I know he has a background in business, if I recall. He is known in the business community. And
Mr. Fragaskatis, point of order there from Mr. Julian.
I'm sure singing the praises of Mr. Kelly is something we'd all like to do, but it is not relevant to the sub-amendment. And if Mr. Fragaskatis has nothing else to contribute to the debate, let us proceed to the vote.
Okay, we have 4 other people on the lineup right at the moment, including yourself, Mr. Julian. Mr. Fragaskatis, Mr. Julian has a valid point, though, on relevance.
No, and I acknowledge your ruling there, Mr. Chair. I always strive to keep it relevant. If for a few seconds there, I broke I believe the 20-second rule that Mr. Julian has talked about in the past, then I really apologize. But actually, by the intervention here, what the opposition and if they wish to raise points of order, it's obviously within their right to do so as MPs working on committee. I have to put on record here again, Mr. Chair, that when the accusations were launched against the clerk by Mr. Polyev, I didn't hear anything on the part of the NDP. Mr. Julian did not raise his voice, and those who replaced him at committee when Mr. Julian stepped out for a few hours, I believe in the last meeting that we had on the subject, and in meetings before that, Mr. Chair, nothing was put on the record from the NDP that has, at least in its rhetoric, consistently put forward a message that would have Canadians believe that they have real respect and admiration for public servants. But here we have Mr. Julian working with the Conservative opposition and Mr. Poilievre, which is an interesting alliance, to put it mildly, and to be very polite about it. But I leave that there, Mr. Chair. I know that others do want to speak. I have more ideas on the importance of never attacking public servants and never politicizing, by extension, the public service, or at least debates that would tend in that direction, Mr. Chair. I'm glad to bring those matters up later on, but I know that I think it's Ms. Darowitz who is at the edge of her seat, getting ready to put forward a speech that we're all ready and excited to hear. So with that said, Mr. Chair, I'll turn it over to my colleague from Davenport.
Oh my goodness.
Thank you, Mr. Fragiskatis. That's quite an introduction, Ms. Sarowitz. You're on. The floor is yours, and I can see Mr. Julian with it in his eyes, looking for relevance already. Ms. Zarowitz.
Well, first I want to say, so first of all, thank you, Mr. Chair, and I want to say thank you to my colleague for sort of giving me such a, an introduction. I'm afraid I'm going to probably disappoint. I'm not ready with any oratorical speeches at the moment, although I probably have a few interesting things to say before I go into some prepared remarks. And to be honest, a lot is I think expanding actually on where Mr. Fragiskatos has been. It's been exactly along the lines that I've been thinking about, and so I'm expanding on some of his points. But here's where I'm going to start off. I'm going to say that we on the government side do not believe, and I say this wholeheartedly, we don't believe that we're hiding anything. And I always like reminding everyone who's listening, and maybe some of the new colleagues who've joined us today on this at this committee meeting, that we actually had almost 2 months of testimony over the summer just to look into the We Charity being selected to deliver the Canada Student Summer Grant, so CSSG program. And we have heard very clearly through that testimony that there was no corruption, there was no misuse of funds, that we was actually independently selected by civil servants, that the reason we rushed before the summer was because, we knew that university students really wanted to be able to access as much money as possible so that they could fund their continued education, that we went to a contribution agreement and not a sole source contract for very deliberate reasons, and we explained that, and that we absolutely did this for students. And not only did we introduce the CSSG program, but we introduced over $9 billion of supports for students, and the vast majority of that money has gone out. It's been very helpful, and it's been very helpful for, my nephew who's now at Brock University, and I'll tell you, he laments that school's not fully back into session, but I know that he's taken advantage of some of the programs because he needed to. So I wanted to put that out there because I think it's very important. The 5,000 plus documents, I think there's around 5,600. It does not have a smoking gun. There's no smoking gun in there. And what the sub-amendment that's before us and what it tries to get to us is we're trying to say, let's bring all the parties relevant to this matter, to the redactions, to the documents and why things were redacted. Let's bring them around the table so that we can address any outstanding questions, any outstanding concerns, and try to address them in a public way, in a transparent way, so that we could move on. And we could move on to pre-budget consultations, which is a motion I had introduced at our very first session after we had come back from prorogation, after we had listened to the speech from the throne, and that was, I believe, on October 8th. I did want to start off a little bit, and I wanted to, I found something that I was reading in the paper that I did want to share with you. This was from the Toronto Star over the weekend. And there was a foundation that decided, it was a group that actually had been very involved with the We Charity for over 10 years. And they took out a full-page ad and they said the following, and it's exactly relevant to what we're talking to. It says the hashtag We scandal is the loss of the hashtag We Charity. And he says the following: my name is Andy Stillman. I believe in smart, impactful philanthropy. That's why for nearly a decade, my family foundation supported We Charity. But over the past months, I've been confused, reading negative press about We and its founders. If you're like me, you want to cut through the politics and get to the truth. So that's exactly what I did. I hired top-rated, nonpartisan investigators and forensic accountants, including Matt Torrigan, former Deputy Solicitor General for the province of Ontario, and forensic accountant Dr. Al Rosen, who has appeared before the Supreme Court of Canada. The review included over 5,000 pages released by the federal government and nearly 400 documents released by the We Charity, as well as a full evaluation of We Charity finances and that of the social enterprise MeToWe that funds the charity. The findings convinced me so much that I want to pay for a full-page ad to ensure that Canadians have the truth. Here are the top 5 things the experts found. 1, the public service considered multiple other charities and groups, and the public service determined that We Charity was the best partner to administer the Canada Student Service Grant to help students. 2, the Prime Minister's office did not predetermine that We Charity would be selected to administer the Canada Student Service Grant. 3, We Charity would have made no profit from CSSG, but only been reimbursed for eligible expenses to administer the program. We Charity was clearly motivated by helping students. 4, MeToWe social enterprise has created jobs to help lift people overseas from poverty and given 100% of its profits to We Charity or reinvested funds for social purposes. 5, Mark and Craig are volunteers who never profited from We Charity. In contrast, the Kielburger family are among the most generous financial supporters of We Charity. Simply put, there was no funny business. The real hashtag We Scandal is politics causing the loss of an incredible Canadian charity, which has helped millions of young people for over 25 years. See the facts for yourself at friendsofwe.org and learn how you can help right this wrong. I remain a believer in We Charity and I will continue to support them. Today's world needs more youth volunteerism, not less. We need to take a step back, think critically, and check our assumptions. It is my hope that these reports will renew your confidence in an important organization like it has mine. If you want your voice heard, I hope you'll share your We story of impact with Friends of We. So I just want to say that because, again, it validates the reason we're actually talking about a sub-amendment to an amendment to an original motion. The original motion had an implication that we had that there was redaction done by our independent civil servants that was actually hiding things, that was some sort of a smoking gun, that was really covering up some sort of a big scandal or some sort of a big cover-up. And that's indeed not the case. So again, because of the 2 months of testimony we've had, and then I found it so interesting that you had an amazing, this foundation who decided that they were going to hire their own independent investigators and forensic accountants to actually go see whether there was any funny business. And then when they found the results, decided we have to go out and put out these ads. And it was really important for them to do so. So I thought I'd start off with that, Mr. Chair, because I think it's important for us to put that on the table. So getting back to the sub-amendment. So again, the reason we want the sub-amendment to pass is it was our attempt on the Liberal side to try to get, it was our attempt to try to deal with any concerns of maybe there was some sort of document that hid some big secret or some cover-up so that we could sort of move as fast as we could to pre-budget consultations. But I'll tell you, now it feels like, because we've had a number of discussions, it feels like where we're at is that I think there's agreement on that will eliminate cabinet confidence, will eliminate anything of national security. But I think where we're kind of sitting is that there's some redactions within the original set of documents that went to the law clerk that had zero relevance to We at all, that never needed to have been submitted, but because they were just part of the documents, ended up being submitted. and they were just automatically redacted. And I think what's important to state is just if those sections were not included as part of the submission, no one would have ever complained because it was never part of the original intention to be included. Anyways, I don't know if any of that's clear, but we have a few hours to actually make it clear. And where I'm going to take us is actually where my colleague, Mr. Fragiscatos, had talked about, where he indicated that Mr. Shugart, our clerk of the Privy Council, had submitted a very clear letter to the clerk of our committee indicating the following. I'm writing further to recent discussions at the Standing Committee on Finance. My colleagues and I would be pleased to make ourselves available to appear before the committee to speak to the redactions that were made if it would be useful to do so. And so I want to sort of then move on to say that there seems also to be I'm just trying to see where I want to start in my speech here. I know that we've been discussing the documents requested by this committee for some time now, and I think it's fair to say that there's some disagreement among parties in relation to the redactions of non-relevant cabinet confidence by the public service. As well, there seems to be clear confusion in regard to who redacted which set of documents that are floating out there. And just recall, if you actually look at the sub-amendment that we've put on the table, we've actually proposed that we actually bring forward to the committee both sets of documents. So the set of documents that are coming forward from that were redacted by our independent civil servants. So that's package number one. And then package number two is the package that came back from the law clerk that was further redacted so that we could see what were the differences. So that is part of that. In any case, there seemed to be some confusion in regard to who redacted which set of documents. We have the very comprehensive set of documents released by the government House Leader, which had some light redactions in relation to personal privacy and unrelated cabinet confidences. And then we have redactions completed by the law clerk, which were intensive. I want to know on the first set of documents, the redactions and the instructions came from our law clerk. And I know that Mr. Fragiscatos sort of talked a little bit more about it was the clerk who gave very clear instructions to all departments as to what information needed to be released. What I want to add to the discussion is that cabinet confidence is actually very clearly defined. And there's actually 6 short points that actually is defined in terms of confidences of the Queen's Privy Council for Canada. And it's a subsection of our Privacy Act. And it says the following: the Act does not apply to confidences of the Queen's Privy Council for Canada, including, without restricting the generality of the foregoing, any information contained in a memoranda, the purpose of which is to present proposals or recommendations to Council. B, discussion papers, the purpose of which is to present background explanations, analysis of problems or policy options to Council for consideration by Council in making decisions. C, agenda of Council or records, recording deliberations or decisions of Council. D, records used for or reflecting communications or discussions between ministers of the Crown on matters relating to the making of government decisions or the formulation of government policy. E, records the purpose of which is to brief ministers of the Crown in relation to matters that are before or are proposed to be brought before Council or that are the subject of communications or discussions referred to in paragraph D and F draft legislation. And I think it's important just to point that out, just because I think just for anyone who's listening, and to be honest, I had to learn this as well, and I learned it as part of all of these discussions. It's very clear when formal documents are actually requested, there's very clear guidelines about how to define cabinet confidences, how to actually define items of national security, and how to define things that are irrelevant. So I wanted to just make sure that I put that out there. So as a result of the proper instructions that came from the clerk of the Privy Council, several departments undertook to release an unprecedented level of information, including cabinet confidences relating to the CSSG. Over 5,000 pages were disclosed and included documents that would have never seen the light of day Well, it says here in my notes, would have never seen the light of day under the previous Harper government. And I think that comment just highlights the point that I think that our government has tried our very best to be as transparent and as open as possible. And I think the release of an unprecedented amount of documents is part of that. And I'd also point out, and I've pointed out this before, but I think it's important to note, our Prime Minister did not prorogue Parliament until all of these documents were formally released into the public. And I think that's a very important note to reiterate, because that to me is another clear action that our Prime Minister wants to make sure that there is no perception, indeed, and that there's no that there's no desire on our part, and to show very clearly that there's no desire on our part to not release the full documents that has been agreed to at our July 7th finance meeting. Okay, so the release of these documents is significant, Mr. Chair. Now, the opposition members can take, umbrage with the fact that some redactions were made by public servants, but I think it's to be expected, and I explained how that there's very clear definitions about what redactions need to be made. And I'd also probably say to you that my sense is that there's probably a lot of training that goes into making sure that we only redact what we need to redact, and everything else is made public. To my friends in the Conservative Party, as they will know, Mr. Poilievre especially, typically cabinet meetings are not solely focused on one topic. Particularly during this ongoing pandemic, countless important topics are discussed at cabinet and relevant decisions are taken. So in order to ensure the proper functioning of responsible government, reasonable redactions were made to unrelated topics, including these cabinet documents, so as to allow for their release. So this isn't out of the ordinary, and I wanted to make sure that I reiterate that. Let me see if I could just move on here. So now we have in possession this letter from Mr. Shugat, who wishes to come before this committee along with the relevant deputy ministers to discuss the documents that were released by the Government of Canada. And because of Mr. Shugat's position and his initial commitment to release all documentation related to the Canada Student Service Grant, he's in fact uniquely positioned to answer questions. And therefore, Chair, that begs the question, why does the opposition not want to hear from the clerk and the relevant deputy ministers? And I'd also say, as it relates to this sub-amendment, why would we not want to bring our clerk of the Privy Council and the law clerk together at the exact same time, which is what the sub-amendment actually also highlights. I also want to mention something that Mr. Poilievre had indicated in the last session. I don't know if other members of the Conservatives also mentioned that, but I do recall Mr. Poilievre saying this a number of times. There seemed to be an implication that our clerk of our Privy Council is not independent, and I think that that's troubling. And I had pointed out very quickly that, you can't have, if you're in government, so the Conservatives were in government for a while, we had assumed, that means Canadians, that means all other parties, we assumed that our public service will be independent and act independently, and they'll do that irrespective of whichever party is actually in government. And so I absolutely believe that that is true right now. And if Mr. Poilievre or other members believe that for some reason our public service is not independent anymore, this is a much bigger issue that we need to address. And it's not the focus and should not be the focus for right now. But I'm just pointing out something that is very troubling in terms of that line of questioning, or that type of maybe sort of, I want to say indirect sort of accusation, but it is fairly direct. I truly believe our clerk of our Privy Council, who had, and this has been pointed out, who was a deputy minister for Mr. Poilievre when he was a cabinet minister in previous governments, that at that point Mr. Shugat had acted independently. And I absolutely believe that the clerk of the Privy Council, again, who is now Mr. Ian Shugart, that he absolutely is acting independently as well. And I think it is not, I was going to say it's a slippery slope, but I don't even think it's a slippery slope. I don't think it should be any kind of a slope that we should sort of be going down in terms of saying in any way that our civil servants are not independent, are not acting in the best interests of Canadians, in the best interests of all Canadians. So where am I going to go from here? I think one of the things I'd like to get to is just the whole thing of why it is. I mean, and to be honest, to be honest, I prefer that we're on to pre-budget consultations right now, and so I'm not quite sure why it is that our opposition is not allowing us to hear from our clerk of our Privy Council and from our law clerk. So, and honestly, Mr. Chair, I've never heard of parliamentarians refusing to hear from these independent civil servants, and the very act of refusing to allow them to testify here at committee has the effect of effectively politicizing our public service. The public service in this country is expressly nonpartisan for a reason, so it's absolutely unacceptable that the opposition are taking the position that they have. So let's put partisanship and politics aside for a moment, Mr. Chair. Let's acknowledge the facts at the instruction of the clerk at the Privy Council. The public service compiled documentation as they related to the Canada Student Service Grant. In keeping with the motion of this committee, cabinet confidences were removed. That is a standard practice, and I talked a lot about that before, and I know everybody knows about it. The clerk added only one caveat to his release of these documents, that personal information was removed from the documents. Even then, the name of political staff and public servants was left visible. Only phone numbers and unrelated family member names were removed, as the clerk indicated in his letter to us. The law clerk, upon receiving the documents on August 8th, went about his duty to review the documents for personal information as indicated by the committee motion and redacted appropriately. Those are the blacked out documents that the opposition members are waving around in moments of, it says here on moments of grandeur, but I think it's also opposition waving around the same documents in French and in English. And so, and I want to get this on the record, Mr. Chair, I do have the utmost respect for the parliamentary law clerk and the work that he does. And I know that the role of the law clerk is essential to the functioning of Parliament and in protecting its rights and privileges. And like most lawyers, he's going to always defend the rights of his client strenuously, and his legal opinions will always take the most conservative view of Parliament being the ultimate authority amongst three branches of government. And this makes complete sense. That's his job. And I'm happy to have him on my side. And I think he's done great work on this file under the most strenuous circumstances, in particularly the pandemic. However, the clerk of the Privy Council and public servants at large also have inherent responsibilities. For them, it's to the Crown to protect Crown secrets and uphold and enforce the statutes and legislation passed by the legislator. This leads us to the tension. This leads us to, I think, normal tension. And this, I think, doesn't just exist now. It's always existed. There's always going to be tension between the law clerk and sort of the clerk of the Privy Council as it relates to this type of sort of release of documents. The law clerk is always going to take the most expansive position on the rights of parliamentarians for access to documents, and the clerk of the Privy Council, and by extension, the public service, are always going to take the opposite position, that cabinet confidences have to be protected and upheld at all costs. Typically, we resolve this tension through negotiation, where there's a happy medium is found. I think that is where we ideally want to go. And I think that's the reason, Mr. Chair, we have proposed a sub-amendment. Let's bring both to the table. I have said time and time again, we had already, through the testimony of the 2 months over the summer, have already proven that there's no scandal and there's no cover-up, which Mr. Poilievre, I think, is very fond of theatrically sort of saying that there is. There is no smoking gun in terms of any of the 5,000 plus documents. And don't even just take our word for it. I think you also have this independent foundation who'd been very involved with WE, who became very troubled with all these allegations about WE, and independently hired the former Deputy Solicitor General for the province of Ontario and forensic accountants, Dr. Al Rosen, who's appeared before the Supreme Court of Canada, to also validate that there is no, as he says, no funny business. So I think with that, the only thing I would leave everyone with before I sort of pass the baton on to the next person who would like to speak is, at this point, I will tell you I'm really quite worried about our pre-budget consultations and wonder whether we can give really the proper time that is needed to the almost 800 organizations, individuals, corporations that have made submissions to us. You know, I have an interview that I'm supposed to be doing about what happens if there's no pre-budget consultations. I truly believe in the work of our government. I truly believe in the work of this committee. I believe that we have important work ahead of us to not only listen to those that are going through an unprecedented pandemic, but also to hear their very best ideas about how is it that we can not only support them as organizations, as corporations, but also how we could support Canadians overall. And how can we get our economy back on track? How can we actually not just create a strong foundation, a strong economic foundation from which to pivot after we come out of this pandemic, but how is it that we can also set ourselves up to be even more competitive, to address some of the structural financial issues that we have had in the past? How is it that we can put our best dollars, our capital to work to become as competitive as we can? And how do we address maybe some of the other bigger issues we have in terms of trade surpluses? So it's really important for us to try to get past this. Mr. Julian, I've heard him say a couple of times, and I know he's about to speak, so I'll probably respond to this. I know he's mentioned a number of times that he's put all these ideas on the table. And quite honestly, Mr. Julian, I've not heard of all your ideas on the table. I've only heard a no, or there seems to be reluctance to actually agreeing to the sub-amendment so that we can actually maybe bring all the actors to the table and try to get past this so that we could have a certain number of meetings and considerations for pre-budget consultations, and that we could put forward these very excellent ideas to our Minister of Finance, to our Deputy Prime Minister, to our government, so that it can be incorporated into a much awaited and much needed budget 2021. So I think with that, I'm going to say, Mr. Chair, thank you so much for give me the floor, and to everyone for lending their ear. Thank you.
Thank you very much, Ms. Zerowitz. On my speaking order is Mr. Julian, Ms. Koutrakis, and I still have Mr. Fragiskatas on. I don't know if you're on after that or you just didn't take your raise hand function down. Mr. Julian, the floor is yours.
Mr. Chair, through you to the clerk, if the clerk could read the sub-amendment, please.
Madam Clerk, could you read the sub-amendment? I have it here. Go ahead, Mr. Julian, or Madam Clerk.
Okay, that the amendment be amended by adding after the words current session the following: that the committee requests the complete package of documents provided to the Office of the Law Clerk and Parliamentary Counsel of the House of Commons by relevant deputy ministers or the signatories of the transmittal letters, as well as the final package of documents that the Law Clerk and Parliamentary Counsel of the House of Commons approved for release, that both of the documents packages be provided to the committee no later than October 19, 2020, and that after the committee reviews the two different versions of the document, the committee invite each of the relevant deputy ministers or the signatories of the transmittal letters, as well as the law clerk and parliamentary counsel of the House of Commons, to give testimony regarding the redactions applied to the documents that were requested and granted in the motion adopted on July 7, 2020, and that until such a time as this testimony is complete, debate on the main motion and amendment from Pierre Poilievre be suspended, and that the chair be authorized to schedule these witnesses and convene a meeting to resume debate on Pierre Poilievre's motion once these meetings have taken place.
Okay, Mr. Chair, I'd like to propose the following amendment: that we strike everything from until. So the final sentence that suspends and destroys the point of privilege, and that we add, and following a vote on the point of privilege, that the committee proceed immediately to committee discussion on pre-budget hearings.
Just can you, Mr. Julian, can you go through that again a little slower?
So the final sentence, the clerk could perhaps read it again, that starts with until.
Until such time as this testimony is complete. Just you're muted, to Madam Clerk.
Thank you. So until such a time as this testimony is complete, debate on the main motion and amendment from Pierre Poilievre be suspended, and that the chair be authorized to schedule these witnesses and convene a meeting to resume debate on Pierre Poilievre's motion once these meetings have taken place.
So again, my amendment to the sub-amendment is to strike everything from until till the end of the sub-amendment, and to replace it with and that the committee proceed immediately following a vote on the point of privilege motion to discussion of the pre-budget hearings.
Okay, I think, Madam Clerk, I'll have to ask this of you, because we are into a sub-amendment to the amendment of the motion. Do we need unanimous consent to do that? I believe we do. I'll wait for the clerk to she knows the rules better than me. I see her turning pages there.
Point of order, Mr. Chair.
Point of order, Mr. Fragaskatis. We are waiting for the clerk to give me clarification on that point. I don't believe it's allowed, but go ahead. Go ahead with your point of order.
I wonder if text can be sent. I mean, I know Mr. Julian did read that, but it's always easier, I think, if text is made available to members so that we can further consider.
Yeah, we'll just read your amendment to the sub-amendment again, Peter, while the clerk is clarifying this point. If you could read it again, that after.
From the word until the end, the part.
I'm a little lost. You're removing before until or after until?
Including the word until.
Yeah.
Right to the end of the sub-amendment.
Okay.
I'm striking that and replacing it with, and the committee move immediately following the vote on the motion of privilege to consideration of the pre-budget hearings.
A point of order, Chair.
Okay. I'm going to need clarification from the clerk here before we do anything. But what's your point of order?
I was simply going to ask if that is available in French as well.
Okay.
Alors, Monsieur le Président, alors en BIF, toutes les choses qui vont jusqu'à.
So delete everything after until and add the point saying that the committee will proceed immediately to the pre-budget consultations following the vote that will take place on the motion of privilege, more or less. Mr. Sainte-Marie will probably tell me that it's not the perfect translation, but it's the best I can do.
Okay, Madam Clerk, I do think I have to roll the amendment out of order, but I'd like clarification for sure from you.
Thank you. I'll just draw your attention to page 542, 543 of House of Commons Procedure and Practice, 3rd edition. at the last line, we say, since sub-amendments cannot be further amended, a member wishing to change one under debate must wait until it is defeated and then propose a new sub-amendment.
Okay, so it is out of order, Mr. Julian. This one will have to be dealt with, and then you can, well, it's amending the sub-amendment, so I guess you'd have to start in a new place. Go ahead, Mr. Julian, the floor is still yours.
Thank you. Thank you very much, Mr. Chair, because what we've been hearing from Liberal members all along is that it's something about having the clerk of the Privy Council before committee, and that is obviously not the case. Their sub-amendment kills the motion of privilege, and that is what the core of the problem is. For a month now, we've had Liberal members absolutely stonewalling and stopping the work of the Finance Committee, refusing to proceed to pre-budget hearings. And the reason why they're doing that isn't because of some differences around witnesses. I don't think there's a single member of the Finance Committee that objects to a hearing from the clerk of the Privy Council or the law clerk on this. It's to kill the motion of privilege. And this is the core of the issue. The Speaker, who is elected by all members of Parliament, has the ability to rule on this motion of privilege. All that the committee is doing is flagging what is a grave concern. And the grave concern is the censorship substantially of 1,500 pages of documents. That is what was delivered to the Finance Committee in response to the motion that I tabled on July, and that in July 7th, and it was voted on by the entire committee. So we have substantial censorship of the documents, redaction of the documents. We have the law clerk that drew our attention to this immediately. We have a motion of privilege that is a very valid motion of privilege, but government members refuse to have this committee rule on that and actually have the vote. Why? What is it in the documents that they don't want us to see? And so the issue is not, as the government members have tried to put forward, the issue of whether or not the clerk of the Privy Council comes to committee, whether or not the law clerk comes to committee. The issue is trying to kill a motion of privilege, because as you know, Mr. Chair, when a motion of privilege is submitted to the Speaker, it has to be in a timely manner. Now, we can justify with the filibuster that Liberals have undertaken for the last month, not submitting it to the Speaker in a timely manner. But for the committee to decide, that it is not going to proceed it, means that the motion of privilege is killed.
I do have a point of order, and I'll have to take it first, and then I'll let you proceed. Mr. Fragiskatis, you're muted now.
Thank you, Chair. I'm listening to Mr. Julian, and he's implying that improper redactions have occurred. That's quite the accusation. So I have a hard time following the argument without agreeing very
Mr.
strongly.
Fragiskatis, I don't believe that is a point of order. If you want to enter that into debate, you're more than welcome to it, because Mr. Julian has made that point. But I'll go back to Mr. Julian because that is debate. Mr. Julian.
Thank you, Mr. Chair. The reality is, I do feel that it was improperly censored. A lot of members of this committee feel the same way. But it's not up to my opinion or to any member of this committee to voice their opinion. All we can do is inform the Speaker of our consideration around this, and it is up to the Speaker to judge. That's the issue here. We believe we should be referring this matter to the Speaker. Government members have been stonewalling now for a month, destroying any possibility of having the thorough pre-budget hearings that committee members would like to have engaged in, and are basically stonewalling the progress of the committee. Now, if government members feel that there is a way through this, it is exactly the amendment to the sub-amendment that I just tabled. If government members really just want to hear from the clerk, and if government members just really want to hear from the law clerk, then they should amend their own sub-amendment, allow for the motion of privilege to be voted on and referred to the Speaker, and the Speaker determines, none of us, the Speaker determines whether or not there's grounds for a violation of privilege. That's up to the Speaker. Speaker elected by all of us. And if government members are saying they have no confidence in the Speaker, well, I would be very surprised, in fact, stunned that they would be that critical of the officer of Parliament, the Speaker that we have chosen collectively as members of Parliament. I have confidence in the Speaker. I have confidence in the Speaker ruling on this in an independent way based on what the committee refers to him. And so, if government members really do want to proceed to the pre-budget hearings, if government members really have confidence in the Speaker, and if government members are saying, well, also we'd like to hear from the Clerk of the Privy Council and the Law Clerk, I'm fine with that, of course. But they then have to amend their sub-amendment, pull out the part that kills the motion of privilege, that no longer makes it timely, that no longer allows this committee to report back to the Speaker and ask the Speaker his opinion on this matter. They should amend it, and as I've suggested, they have the power to do so. I hope they do so rather than continuing to engage in this filibuster, which has stopped up the work of the Finance Committee for over a month. They have many different paths that they can take to work with the opposition members. They have refused all so far because their intent is to kill the motion of privilege. Their intent is to withdraw the right of the Speaker to rule on this issue. And I find I am in complete disagreement with their approach, and I find disingenuous their speeches this evening. Thanks, Mr. Speaker.
Thank you, Mr. Julian. I believe now on my list is Ms. Koutrakis first, followed by Ms. Khalid. Ms. Koutrakis, floor is yours.
Thank you, Mr. Chair. I wanted to thank my colleague, Mr. Julian, for his comments. And I just wanted to say that we too have confidence in the Speaker of the House, as he does, and all our colleagues, I believe, in the House. But we also have a lot of confidence in the law clerk to make the judgment based on fact. So I think, both arguments can be said and should be considered before we make a final decision on how to proceed going forward. Mr. Chair, I can remember a time not long ago watching the proceedings of this place where members of Parliament were able to set partisanship aside and work together and come to a consensus on how to handle the issues of the day. It really is a shame to see the polarizing politics that we have seen taken hold in other countries throughout the world, and continue to creep into our own Parliament, in the Parliament of Canada. Unfortunately, this is most present in the tactics or strategy of my colleagues from, opposition parties. Now, before Mr. Julian begins to play defense for Mr. Poilievre and tries to call relevance on me, I'm hoping for a few moments of latitude, because I will be coming to my point in regards to the sub-amendment, not the sub-amendment to the sub-amendment that Mr. Julian discussed, but the first one. However, it requires a few moments to lay the track before arriving at that station. Chair, it is so clear in the attitude of my conservative colleagues, especially, that they have fully bought into the misinformation tactics of the extreme right. It's never been more present than the initial purpose for the debate that we're having here today. We are here on Mr. Poilievre's privilege motion, and in debating that we have an amendment and further a sub-amendment on the floor, and perhaps another one now in regards to that motion. But the initial motion is what is key here. And it is the reason behind the sub-amendment before this committee today. The clerk of the Privy Council is an expert witness on the releases of cabinet confidence. Funny enough, it was Mr. Shugart who agreed to release all documentation related to the Canada Student Service Grant, even prior to this committee making any requests. And the appearance of the clerk of the Privy Council really is important as it relates back to Mr. Poilievre's initial motion. Because the truth is, this matter of privilege raised by the honorable member is nothing but what it appears a cheap partisan stunt. It's complete mistruth wrapped in a procedural bow meant to further the narrative of the Conservatives. And that is a tactic of the extreme right, which we have seen throughout the world as of late, Mr. Chair. This penchant for casting the truth aside and continuing to make an argument that has no basis in reality. As many of my colleagues have said before this committee, over 5,000 pages of documents were released by the Government of Canada, with all information relating to the design and implementation of the Canada Student Service Grant, present and accounted for. I think the opposition was just plainly dumbfounded at the level of details that the nonpartisan public servants left unredacted. Mr. Poilievre must have just been completely stunned to see that documents stamped secret and confidence of the Privy Council were actually included in the documents and unredacted. Now we could find out exactly why those documents were included if we had the clerk come before us and testify about that. Yet for some strange reason, my opposition colleagues are blocking that attempt. It's a whole new world, Mr. Chair, when opposition members are blocking the appearance of the nonpartisan head of the public service. It's truly a shame, a real shame. However, getting back to my point, I'm very sure that my colleagues were shocked at the level of detail included in these documents. So at this point, the Conservatives and perhaps other opposition colleagues have a problem or had a problem. They were likely sitting there thinking, wow, they actually released all the docs. Between that and the testimony, we have nothing. I cannot imagine the sinking feeling they had when they realized this. Yet what is the truth, Mr. Chair? Well, to my colleagues on the other side, truth is in the eye of the beholder. So taking a page from these extreme right groups that have sprung up around the world, they have perhaps decided to obfuscate and create their own narrative. And when you think about it, Mr. Chair, this explains why colleagues do not want the clerk of the Privy Council to testify before us today, because his testimony would very likely crush the narrative that they have been trying to peddle for weeks now. As I noted earlier in my remarks, there was a time when civility would win out and parliamentarians would work together to fix the problems of the day. There was a time where the truth would have been accepted when the facts were presented. And unfortunately, we no longer live in those times. We now live in a time where, if after being presented with the facts, your argument is disproven, you double down anyway. When you are presented with expert witnesses, you attack their credibility or stop them from speaking.
Ms. Katrakis, point of order from Mr. Lawrence. I believe, Mr. Lawrence, go ahead.
I'm a patient man. I have a 5 and a 6-year-old, and they've taught me patience. But when we're talking about Mr. Julian perhaps being part of the extreme right, I think perhaps we've gone too far. I have no idea how this has anything to do with the sub-amendment.
Point of order, Mr. Chair?
Just that wasn't a point of order. It was a point of debate. Mr. Fragaskatis, is yours debate or point of order?
I believe it is a point of order, Mr. Chair, because I think it is simply a matter of being respectful and collegial towards colleagues to allow them to finish making their points.
I don't think that's a point of order, Mr. Fragaskatis. We'll be going back to Ms. Koutrakis. That's debates. Ms. Koutrakis.
Thank you, Mr. Chair, and I thank my colleague for his point of order. I guess we're going to agree to disagree on that point, but I'll go back to my comments and say I have never in all my time as an MP, and it's just a little bit over a year, see the opposition party refuse to allow a public servant with relevant information testify before a committee, especially when that public servant is a top boss. I've said this before in previous comments where, and I echo what my colleague Ms. Zuru said earlier, if we place doubt in, the clerk of the Privy Council, then we absolutely have a much bigger issue on our hand, much more than debating, the sub-amendment to perhaps another sub-amendment. It was clear from the outset what this committee requested in regards to documentation. And it was clear from the testimony by the clerk of the Privy Council here what we would receive from him. And in fact, again, over 5,000 pages of relevant information were released with limited redaction. The clerk noted that he would endeavor to ensure that this committee would have the information it needed to fully understand what occurred with the design and implementation of the Canada Student Service Grant. He kept up his end of the bargain. My colleagues on the other side know full well that the redactions that are present in those documents are about unrelated matters, but due to the nature of the document, were redacted to allow for the information about the CSSG to be present. I mean, the law clerk himself redacted further, not only when he received the documents, but he redacted some of the redactions, my understanding. The motion from this committee recognized that these unrelated cabinet confidences would be redacted. This committee also understood that the parliamentary law clerk would remove some personal information from the documents as well. The clerk of the Privy Council, who could be saying this himself if we invited him here, and I'm happy to hear that Mr. Julian says he wouldn't have a problem to have Mr. Shugart before us, because I really believe we should, sooner rather than later, actually took the extraordinary step, Mr. Chair, of leaving in the names of public servants and advised the Privacy Commissioner that this would be the case. The clerk of the Privy Council cannot control the fact that it was the motion of this committee that later caused the law clerk to redact those very names that the clerk endeavored to release. And if he could be here, he, again, could explain that positioning himself. Now, this committee received these documents on time. They were forwarded to the law clerk, as was expressly stated in the initial motion. And here we have the law clerk completing his own redactions. Right around the time of prorogation, the law clerk released these documents to the members of this committee. Now, the interesting thing here, Chair, is that clearly the level of redactions by the law clerk are much more intensive than the redactions in the original documents as handed over by the public service. In order to ensure full transparency, the Government House leader released the less redacted documents anyway. So in essence, Mr. Chair, the Government of Canada fulfilled the promise of the clerk of the Privy Council and the request of this committee vis-a-vis the motion requesting documents. If the clerk of the Privy Council was allowed to testify, he would back up this very simple fact. And this brings us back around again as to why we are still here debating this sub-amendment, Mr. Chair. Quite simply, we are here because the opposition majority cannot accept that they were actually given everything they wanted. It doesn't square with the narrative that they are trying to put out in public. Just like the testimony of the clerk would not fit the narrative they are trying to put out in public. So here we are, debating this sub-amendment to an amendment to a motion that in the end is just a procedural trick to try and further this cheap political stunt that is now falling apart day by day. Chair, we are weeks into this at this point. We have pre-budget consultations that this committee is mandated to complete, and I fully agree with Mr. Julian, and we have to get to that. We have a fix before us. With one simple vote, we could set aside Mr. Poilievre's motion today, not defeat it, and set it aside. Invite the head of the public service, the clerk of the Privy Council, Mr. Shugart, to this committee. And then he, along with relevant deputy ministers, can present their thinking and reasoning around the documents that were provided. That could walk us through how all discussion and decisions regarding the Canada Student Service Grant were unredacted. They can walk us through why some matters are redacted and how they are unrelated to our topic of study. And they can finally put to rest any concerns of the opposition. I know this wouldn't fit the narrow political interests that the majority opposition has tried to push. I know this would completely blow apart the fictitious narrative that Mr. Poilievre is trying to spin. However, so be it. Mr. Poilievre and the other opposition members want to get to the truth. So here we are. Let's get to the truth. It's time for the nonpartisan head of our public service to come before us and give us the truth. I've done this before. I'm going to repeat my comments again. I urge colleagues to put aside their partisan difference, to finally return to past times of collegiality and decorum in Parliament, to remember we are here in this place to serve our constituents and to put their interests first. Let's show some respect to our professional and nonpartisan public service, not use them as ploys in a political game. Mr. Chair, I ask colleagues to work with us to approve this sub-amendment and to invite the clerk and other deputy ministers here forthwith. Thank you, Mr. Chair.
Thank you, Ms. Koutrakis, and I'm hopeful for discussions on the side as well. I have on my list Ms. Khalid, Mr. McLeod, Mr. Fragaskatis, and Ms. Zerowitz. Go ahead, Ms. Khalid.
Thank you very much, Mr. Chair, and thank you to all the members for indulging my participation in the committee today. Mr. Chair, if it's okay with you, can I please concede the beginning a few minutes of my
Chair,
time
point of
to
order.
Ms. Derowitz?
Just a point of order, Mr. Fragaskatis.
It's my understanding that every MP is an associate member of the committees of Parliament, and so it's no indulgence at all. Ms. Khalid is here by right, and she's very polite and generous to talk about indulgence, but I think it's our pleasure to have her here. So just wanted to put that on the record.
It's absolutely our pleasure to have her here, as well as it is Mr. Lawrence, and we've had others from time to time, and you are sworn in the place of Mr. Fraser, I believe, or notices went to the clerk, rather, that you're in his place. Go ahead, Ms. Khalid.
So as I was saying, Mr. Chair, if it's okay to have Ms. Zerowitz take a few minutes of my time at this point, because I'd like to add on to what she has to say as well.
Okay, if you're ceding some time to Ms. Zerowitz, go ahead, Ms. Zerowitz.
Thank you so much, Mr. Chair, and thank you to my honorable colleague, Ms. Khalid, and welcome to our committee. And I appreciate the nobleness of Mr. Fragaskatos' comments. He's indeed correct. So I wanted to just because sometimes when people make points, I kind of forget it, and as I get older, I do forget my comments, and I prefer to make them almost right away. Mr. Julian had made a number of comments, and I want to address them directly. The first is that we're holding up the Finance Committee from moving forward to pre-budget consultations. And in this meeting, I've not said this, and it's very important for me to reiterate it. On October 8th, when we first convened as Finance Committee, after we had elected our chair and our vice chairs, I presented a pre-budget consultation motion. I was the first one out the door to do so. We could have gone ahead with it if Mr. Julian or any one of the opposition members decided that they were going to support it. That did not happen. Mr. Poilievre interrupted our ability to move to a vote to decide on pre-budget consultations with the motion on a point of privilege, of which part we have gone to a sub-amendment to motion of the sub-amendment to an amendment of the original motion. So I want to make sure I put that on the table. We had wanted to go right into pre-budget consultations. I do not take lightly anyone saying that in any way the Liberal government team has been trying to stop us moving directly to pre-budget consultations. We have spent, and if you actually look, second, I want to get to Mr. Poilievre's motion, which he indicates that it's this point of privilege where he says that we would vote on saying that our committee, your committee, has concluded that the government's response failed to comply with the order, which is the July 7th order in terms of all of the WE documents be submitted for public to the public and to the law clerk for redactions. And so we have spent every single meeting since October 8th proving that though we have completely followed through on that July 7th motion. We've explained why we felt we fall through on it. We have explained what cabinet confidences were. We explained the transmittal letters. We have gone through every single bit of it. We even gave examples ad nauseum of what was actually redacted. And then we put the subcommittee, the sub-amendment on the table in order to say, look, even if you don't believe us, why don't we just bring the people to the table? Let's bring the clerk of the Privy Council. Let's bring the law clerk. Let's bring any relevant deputy ministers. And let's, in public, transparently, deal with this once and for all, because we don't think there's any smoking gun. There is nothing that we are trying to cover. And we have proposed that motion fairly early on, and that was, again, not taken up, not by Mr. Julian and not by any other of the opposition members. And so I do not take lightly anyone saying that we have in any way try to hold up the pre-budget consultation. If anything, we have done our very best at every moment to try to move as quickly and as expeditiously to pre-budget consultations. And I also want to reiterate a point I've made. Mr. Julian has made zero proposals in terms of new ideas of how we can actually break this logjam. So with that, I just want to say a huge thanks to Ms. Khalid for allowing me a few minutes to actually just address the comments that Mr. Julian had mentioned. Thank you.
Thank you, Ms. Zerowitz. Back to Ms. Khalid.
Thank you very much, Mr. Chair. And you know, as Mr. Fragas-Katos had pointed out, you know, I am an associate member of this committee, but only watch the committee proceedings from the outside. I don't get to see whatever is happening within the committee and to understand the intricate delicacies of all of the motions and the various amendments to the motions, and then the various sub-amendments to the motions, and then as Mr. Julian tried to do today, to move a sub-amendment to the sub-amendment. And you know, as I get on the phone with my constituents about what happens in Ottawa, I had a very interesting call with a young lady who had been following what's been happening with this specific topic over the past number of months. And she asked me to explain to her what is going on. She said, "Well, you know, what exactly is the objective of doing all of this? What are we trying to prove here? Is this going to better our government services in any way? How is this going to impact me personally?" And you know, I guess I listened to her and her frustrations, and then I started to initially try to explain exactly what was going on. And I think we both kind of got lost in all of the proceedings and et cetera. And then she just said, Ikra, she said, "Stop. Can you just tell me one thing that is going to help me as your constituent out of all of these documents that are being put forward, out of all of these questions, you know, like questioning the integrity of the public service or the integrity of XYZ people within those that we elected to serve us." And I thought about it for a minute, and I said, well, you know, I really can't really point to a single thing that would impact the challenges that you're having with affordability at this time, the challenges that you're having with housing at this time, the challenges you're having with finding affordable childcare, with worrying about how your kids are and their safety in their schools, how that's going to go, and about her job. And I you know, as I sat here today and watched with intrigue about the discussions, and to see the sub amendments being proposed here in front of me, and to try to get a grasp of this myself, I think my 2 cents to this debate would be to help us understand, and to add in that extra value of why we're sitting in these seats in the first place, why we are working long hours, why we travel all across the country or halfway across the country, whether it's virtually or in person, to come in to sit in the House to debate a lot of these important issues. Really, why we do all of that, it's to serve Canadians and to ensure that the time that we're spending in these debates is that of value to individual Canadians, to young families that are trying to thrive and strive in this very, very serious pandemic, to make sure that the health and well-being of Canadians is well taken care of. And I think that it's our obligation as members of Parliament, regardless of what side of the aisle we sit on. I know for a fact how hard each and every one of us works. I mean, I sat on committee with Mr. Falk in the last Parliament. We were on justice together, and we had such a wonderful relationship with respect to the work that we were doing in that committee. Again, serving Canadians. We've traveled together.
Miss Khalid, I believe Miss Jansen is making a point. I see her waving her hands around. I don't hear her through the system, but I think she is making a point on relevance. Although I know Mr. Falk wanted you to talk about him on Justice Committee, but I think she's making a point on relevance.
Point of order, Mr. Chair.
Oh, do the same thing.
Is yours point of order? Go ahead, Mr. Fragaskatis.
I believe it is a point of order, Mr. Chair. I don't know Ms. Jansen very well. Obviously, she's a newly elected MP. I would just ask her if she does indeed have an issue, something that she wishes to raise by way of a point of order, that she actually formally intervene, because it's not parliamentary practice to wave one's arms. And I also noticed that when she does have particular issues, she seems to be laughing along. I'm not sure if that is done as a measure of goodwill, or I'm not sure if that's done because she disagrees with the speaker. But she can simply say point of order and intervene that way, rather than forcing you to guess, which is very unfair to you, Mr. Chair. And I think, frankly, the point of order that she apparently wished to make is one I take issue with. Ms. Khalid was staying entirely relevant, and I think was putting on the record very pertinent points.
We'll go back to Ms. Khalid and
point of order, Mr.
and let
Chair.
her start. And Ms. Jansen wasn't waving her fist, so it was just her hand.
Ms.
Zerowitz, go ahead.
Quorum. I see that there's some conservative missing, and Mr. Julian's missing. Perhaps we don't have quorum anymore.
We do have quorum.
Oh, okay. Sorry, just in case. Thank you.
Okay, thank you, Ms. Khalid.
Thank you very much for that, Mr. Chair, and I do appreciate your proactiveness and your diligence in ensuring that that members all have their say and are well respected with their perspectives here in this committee. So as I was saying, and the point that was being raised that I was trying to lend to this debate is that outside perspective of what Canadians who we serve as members of Parliament see and what they interpret when they see all of these amendments and sub-amendments to the sub-amendments and all of these questionings around the integrity of the public service, the integrity of elected officials, regardless of what side of the aisle they're on. So I was giving my personal anecdotes as to what Canadians see, what my constituents and the feedback that they've been providing me over the past number of months, as well as telling me the issues that they're faced with on a daily basis as they deal with this pandemic. There have been a number of organizations that have reached out to me, to my constituency office, to my Hill office, to ask if they could participate in the pre-budget consultations. And I know how important it is that we hear from Canadians to really form that policy, to really provide that assistance and that help to Canadians. As we spend so much time, traveling across the country and doing that hard work that we're elected to do. I'll hit on one more phone call that I had quite recently. I was a gentleman who had just, at the beginning of this pandemic, had lost his job, and I was able to take the CERB, to be able to keep the lights on in his home. And as we were having a discussion last week about his job situation and his intrigue with the new CRB and when that was going to be put forward, he again asked me from that public perspective of what is going on in the House, and I again tried to explain to him. And he used a very interesting phrase that I questioned him on. He said, "Looks like, Ms. Khalid, that you've been condipede." And I said, "Well, what's a condipede?" And he said, "Well, it looks like the House has been taken hostage, dealing and just falling into completely irrelevant matters, into amendments and sub-amendments and all of this extra language that just does not impact Canadians at all." And I told him that using a term like CONDP is probably not the best way, and if Mr. Speaker had been there on that call, would probably have told him it was unparliamentary. But again, to the point, that we need to ensure that whatever we're doing as parliamentarians, that we're doing it with integrity, that we're doing it with a commitment and a focus to support Canadians in this really important time that they have been asking us consistently that now is the time that they need that help and that support. So I will leave it there, Mr. Speaker. I see that you've unmuted yourself. Perhaps it is to talk about something.
I was just going to ask you to tie this into the sub-amendment to the amendment, if you could.
Absolutely. So as I had said, I've been trying to give that outside perspective to what Canadians are seeing when they see all of these debates on all of these, to them, in layman's language, just not understanding why we're spending so much government time and resources when what they really want, what they've really elected us to do, is to provide support to them during this pandemic, during the toughest time in our crisis, in our country, in our history. And I'll leave my remarks there, Mr. Speaker. So thank you very much again for your indulgence.
Thank you very much. We'll go to Mr. McLeod, followed by Mr. Fragiskatis, and then to Mr. Kelly. Mr. McLeod.
Thank you, Mr. Chair. Mr. Chair, it's certainly an honor for me to sit here to serve on the Finance Committee, and I've been doing exactly that for the last 3 years. And I'm trying to listen very patiently to everything that's being said. And I've been around for a long time on this committee. I'm second only to you in terms of longevity, and tied with Mr. Poilievre. And over the last 3 years, we certainly, I think, all worked really hard to speak freely and allow people to speak freely, although it's been a little bit challenging sometimes. And over the last couple of years, our committee has done some very good work, very important work that we can be proud of, from our review on the proceeds of crime, Money Laundering, Terrorism Financing Act, to our hearings on multiple budget implementation acts and our meetings earlier this year on the government's response to the COVID-19 pandemic, and also the work and the efforts we made to deal with the We Charity issue. You know, a lot of information was requested and received, and I don't think we really did justice by not getting together and putting all the documents on the table to go through it as a committee. I come from a different style of governance. The Northwest Territories practices consensus government, and the basis of a consensus government is good communication, and it includes trust, and also includes respect. And we also make we go to great lengths to make sure that people don't attack staff, public servants, and other people who are not present to defend themselves. So it really is troubling to hear when somebody says that the clerk's bonus depends on this prime minister, and it's almost inferring that the clerk would be dishonest and would do it for money, and that's a very offensive comment in my view. Amongst our most significant work is the committee's pre-budget consultation report that is required by standing orders. And this upcoming study would be my fourth with the committee. And I found every one of these studies to be very valuable to my work as a member of parliament. And I believe for all our members that I have served with, it allows us to hear from many witnesses from coast to coast to coast. And they bring many requests for the government's next budget. And this year is no different. And these recommendations would be brought forward into several dozen final recommendations for consideration by the government. Not only do we hear from groups and advocates that we deal with regularly in our constituents, but it allows organizations to address us that members may not otherwise hear from in a regular day-to-day work. And I'm one of 3 members who represents the Northern Territories, and I'm one of 10 Indigenous MPs. And I always try to make it a priority to have Northern and Indigenous voices come before our committee during the consultations. The Standing Committee on Finance has been able to hear from many of these voices during our in-person Ottawa meetings and in our committee tours, which, because of COVID, will not be able to do either.
Point of order.
Go ahead, Mr. Kelly, point order.
And I sincerely apologize to Michael McLeod for the interruption, but I wanted to just ask the clerk if, just to clarify, if we go past 6 p.m., will that interfere with?
It's a very valid point, Mr. Kelly.
So maybe the clerk could tell us what.
I was interrupting Mr. McLeod due to capacity problems on the Hill. The Heritage Committee can't meet if we continue to operate, so meeting suspended.